This is a reasonably interesting post by When Pigs Fly. I figured that a lot of people probably have similar questions, so I'll give it an answer. Thing number one, RAS, is something that judges and lawyers and the police don't use. They use reasonable suspicion and probable cause. So you mark yourself as having sovereign citizen tendencies when you use reasonable articulable suspicion. I'm not saying you're a sovereign citizen, but it's not, the actual term is reasonable suspicion. That's the actual term. It's not reasonable articulable suspicion. I know that in these particular kinds of areas of YouTube, you'll see a lot of it, but it's reasonable suspicion. That's really all it is. You don't have to say reasonable articulable. You could just say reasonable suspicion, and that means exactly what it's supposed to mean. Given that the police are under no legal obligation to state to a detainee his reasonable suspicion, should that prevent the detainee from conducting his own investigation through consensual conversation to determine whether an officer actually has reasonable suspicion in preparation for a civil suit or even a criminal action for oppression under color of law, since reasonable suspicion is required by law? If you are detained, my advice is not going to change. Shut your mouth. Don't talk to the cops. You're not there to prep for a civil suit. You're not there to bring a criminal action. You can't. So you should just get that out of your head right now. Just shut your mouth, and if anything bad happens, let your lawyer know and let your lawyer advise you from there. If an officer actually has reasonable suspicion, wouldn't stating such on body cam circumvent the probability of a costly suit by the detainee? No, it wouldn't, because people sue all the time. And if nothing happened other than a detention, there would not be a costly suit. There'd be summary judgment for the officer on qualified immunity, and done. After an officer is asked to articulate reasonable suspicion and he refuses, doesn't this create a rebuttable presumption that none exists? No, it does not. Just like an auditor must determine through questioning of the officer that detention exists, before he can question whether it is lawful, you don't have to question it. You can simply walk away, and if the officer stops you, you know you're detained. You don't have to question it. If the lights and the siren are sounding and you pull over and the cop pulls behind you, you know you're detained. It's those weird bits where the cop walks up and just starts wanting to talk to you, just asking questions, just being neighborly. That's when you ask, am I being detained? Or just walk away. One of the two. Yeah. So you don't technically have to ask the officer, and the officer doesn't have to answer anything. Wouldn't you agree to this line of questioning? I hate it when people start with wouldn't you agree, because that usually means the answer is no. If someone has to say wouldn't you agree, the answer is probably no. Wouldn't you agree that this line of questioning by a detainee would be particularly useful? Nope, it would not be. It will never be useful, period. In cases where no arrest is made or no report is created in preparation for a civil suit. If no arrest is made and no report is created, I will just tell you right now, you don't have a civil suit. If there's no arrest made and no report created, that means you weren't hurt. If you weren't hurt, there's no damages. I was detained for 15 whole minutes. Or even an hour. The court's going to look at you and be like, yeah, sorry? But no. And my dog is going to lick himself right now, so enjoy that noise. Although an officer is not obligated to respond, not asking these questions would be analogous to an otter leaving his lens cap on. No, it wouldn't. It literally does nothing. You are not helping yourself. You're not changing anything. Please, for the love of God, listen to a lawyer for once in your life and shut your mouth if you're being detained. Unless you're an auditor and you really want to have that interaction with the police to get the drama and the clicks, then talk away. With respect to your commentary on arresting a police officer, did you notice how the auditors in the Leon Valley incident peacefully submitted to arrest based on notice alone? It wasn't based on notice alone. It was based on notice with the underlying threat of force. The police have the right to use force to effectuate an arrest. In Texas, even citizens have a right to use force to effectuate an arrest. The difference in this particular situation is that the police have body armor. The police have firearms, tasers, pepper spray, numbers. You're going to lose. Don't do it. As soon as you try to effectuate an arrest, you touch that cop or threaten to touch that cop, that's probable cause for assault. So that cop can then arrest you using force. It's dumb. Don't do it. You're literally just setting yourself up to be hurt or killed. Have charges brought against you for assault. Assaulting a police officer is no joke. Anywhere you do it, they have protected status. Why wouldn't or shouldn't police officers peacefully submit to notice of arrest? Because they don't have to. Because they've got guns. Because they believe they're right. Because if you start pulling guns, they're going to shoot you. This isn't what could technically happen. What technically could happen in the law is way different than what is likely to happen. And I'm telling you, it's likely that you'll get shot. It's likely that you'll get tased. It's likely that you'll get injured. And it's very likely that you'll get charges tacked on. It's unlikely that a prosecutor is going to bring charges against the police. Especially if it's a questionable situation where, oh, I think this officer broke a law. Really? Are you like, what law do you think this officer broke? Well, I think he's trying to unlawfully arrest me, so I'm going to arrest him for unlawful arrest. No, just don't. Please. For the love of God, just don't. Two simple rules that I'm going to give every client all the time. Number one, if you're being detained or arrested, shut your mouth. Don't talk to the cops. Number two, never try to arrest the cops. You talk to your attorney. Your attorney will probably put you in contact with someone, or you could just go straight to like a federal prosecutor. Maybe try the city prosecutor. Try internal affairs. Sure. Talk to a federal prosecutor. They have tip lines. Call up the tip line. Explain the situation. Tell them, I have evidence on my camera. Let them risk their lives and limbs to effectuate an arrest if they think that there's probable cause. You're not gonna win your lawsuit if you're dead. Here in Nevada, other peace officers are required to take into custody anyone arrested by a citizen. Yes, but you have to arrest them. And what is it, Brenlin? Supreme Court case? Brenlin, I think it is. A person is not seized until either they submit to a show of authority or they are stopped by force. So you say, I'm arresting this man. Officer, take him into custody. He's not arrested yet. He's not seized. You haven't seized him. You have not arrested him because you have not seized him. Unless he submits to your authority, which he's not going to do because he's got a gun. You're being stupid. Stop. The standard for citizen's arrest is reasonable suspicion, not probable cause. That is wrong. It says reasonable cause in the statute, but it says reasonable cause for all the arrests. And the floor set by the Fourth Amendment is probable cause for an arrest. You have to have probable cause for an arrest. Period. You have to have probable cause for an arrest. So, no, you're wrong. It doesn't say reasonable suspicion. It says reasonable cause. I don't know why they wrote reasonable cause. Take it up with a Nevada legislator, but the floor set by the Fourth Amendment is probable cause. You have to have probable cause for an arrest. Of course, a written complaint must be given to the magistrate who is adjudicating the case as soon as practical in order to determine probable cause. Sure. Yeah. And if it's a felony, then it has to proceed under indictment. So, yeah. So the idea of being assaulted and battered by a police officer for attempting to effect his arrest is a bit melodramatic. Really? Really? Especially when one realizes an arrestee must be booked into a government-operated jail and presented before a magistrate, don't you think? So, no, because no, that's stupid. Are you assuming the other officer's there? If you're assuming the other officer's there and the other officer doesn't think you have probable cause to arrest the first officer, then no, you've got two officers now with guns who are going to stop you from doing what you're trying to do. And if the other officer's not there and you manage somehow to subdue this guy, he's gonna roll up on the situation and he's going to see people that have assaulted another peace officer. He might talk. He might take action. It's a bad idea. It's a super bad idea. So I don't recommend it. I think you may wish to reconsider. And I will never, ever try to arrest a cop. I may, if I believe a cop's done something wrong that's arrestable, I will notify Internal Affairs. I will notify the district attorney. I will notify the U.S. attorney. I will call the FBI. I mean, I will let everybody know who I think needs to know. But I am not going to do it because it's stupid. That's how people get shot. So thanks for listening, watching, whatever. Have a great day.